Sir, you keep talking about being an accidental lawyer. ये accident हुआ कैसे? If you were not this accidental lawyer, who would you be?
Probably a theatre actor if somebody were willing to cast me. I wanted to say everything and I ended up saying nothing.
What does it take in your view to fall in the top 1% in your practice or in your country?
Earn the respect of your colleagues, I've always said, is the toughest thing. Okay, what if a judge bullies you? Or what if a judge is not willing to listen to you? The core of the profession has not changed, thankfully. The real glamour is probably in actually making a good argument in court.
The change that I wanted to check with you, and now this is bringing closer to our industry and also globally, is AI.
Your first draft, as they say, should be yours. I've seen some bail orders where non-existent judgments are being quoted.
Our next guest is someone who's a senior advocate from Karnataka High Court. He's a first-generational lawyer. He's practicing in Supreme Court. He's built his practice brick by brick. He's a TEDx speaker. He's a published author. He's a known voice in constitutional matters. I am talking about Mr. Aditya Sondhi. And in this episode, we're going to cover three broad themes: what it takes to become a senior advocate, the trade-offs in your journey, how to build an ethical practice as a senior counsel without compromising any of your values. If you're interested in developing certain skill sets as a lawyer, if you're interested in figuring out how you can use AI and still become a relevant lawyer, or if you're interested in having a very successful and satisfying career, just watch this episode, guys. Don't waste your time. If you think it's too long, just watch it on 1.5x. This is something one of my editor team was also telling me. Just watch it, enjoy it, and let me know in the comment section how you found it. We are here to serve you and make this community a large community for everyone. Welcome to Beyond Billables, sir. It's such a pleasure to have you here.
Thank you, Rohan. Good to be here.
Sir, you keep talking about being an accidental lawyer. ये accident हुआ कैसे?
अब accidents कैसे होते हैं कौन कह सकता है? But it's a fact that it was an accident. I have recounted this many times that I was in Bangalore when I was just finishing my 12th standard. I had really no plans except I wanted to get out of India. And that was my objective. But then I heard of the National Law School in Bangalore. I had no intent or plans to be a lawyer, but I said I'll write the entrance exam. And that would be a respectable plan B to have.
Oh, there was a plan B.
This was, well, you can say a fallback plan of sorts. And it turned out to become plan A because my admission to the UK didn't work out that year. I was not willing to wait another year and give it a shot. And in the process, I was lucky to get into NLS, and that's really the accident, to be honest.
So, आपने कोई entrance examination at that point of time, did you prepare for it or just decided I'm gonna walk in?
मैंने तो बहुत कम preparation की, truth be told, which is why I said I was lucky because it was a tough exam. It still is. It was a competitive exam, and I remember our year was such a long paper that nobody finished it. So when we came out of the exam hall, I thought I have no chance in hell because I barely finished, I think 75-80% of the paper. But then when I spoke to others around me, nobody had finished it. So I thought, chalo, level playing field हो गया. हाँ. But preparation, मतलब थोड़े बहुत पुराने question papers ज़रूर मैंने देखे थे. But as I said, I wrote it, frankly, I wrote it for fun, wrote it for a chance. But it worked out.
And then, sir, you decided that now UK is not happening, so you will go for the law school itself. But did at any point of time you second guess this? Why law? Like, why law?
I did second guess it because 5-year program काफी लंबा है. कम से कम 3 साल के program के बाद तो आप exit कर सकते हो. So honestly, I was not really into it. मुझे उतना मजा भी नहीं आया. And the fault is partly mine because I was really not that keen or driven to be a law student at least. But एक चीज है कि जितना भी accidental हुआ हो शुरुआत में, by the time I was into my 4th year, there were no accidents then. Then I was crystal clear that I want to practice. I wasn't fence sitting. I was quite clear that I was not going to go the corporate way. I had no plans of studying further. And I knew that I wanted to get into court. So maybe शुरुआत एक तरह से accidental थी, but along the way things cleared up.
So how did you, ये आपने बहुत important चीज़ बोली है, आजकल हमारे लॉ स्टूडेंट्स में हमेशा इशू होता है लिटिगेशन कॉर्पोरेट दैट डिलेमा स्टिल कंटिन्यूज.
जी.
आपने कैसे डिसाइड किया? व्हाट मोमेंट और व्हाट एक्सपीरियंस गिव यू दैट क्रिस्टल क्लियर क्लैरिटी?
एक तरह से इंस्टिंक्टिव डिसीजन ही होता है ये. If you understand yourself and you know what your personality is, and if you've been fairly independent in the way you've gone about things, even at 18 or 21, you have a certain core independence in you. And if that's important to you, I think the way forward is court. That's not to say you can't be independent elsewhere. But an internship that I did here with Mr. Dipankar Gupta in 96 or so, my fourth year, cusp of fourth year, was very important because I got to see from close quarters what court is like. And more than, the actual goings on in court and the law and the cases, I got to see his approach and his personality and his ability to bring, 100% to practice. And I think that really appealed to me. I thought that is the way to be in the long run, to have that streak of independent thought, challenge, and also to be, maybe in hindsight I'm glorifying it, but there was a certain, a certain
some
sense
pull
of
also. There was some pull.
A pull that you're going to be in a system that helps you challenge yourself and be a better person. So, yeah.
So somewhere the thought that it's going to challenge me, make me better. कहीं आपके mind में ये भी था कि oh, I like the thought of standing before a judge and presenting my case also?
वो भी था. It's not that मैंने कोई मूड कोर्ट्स किए लॉ स्कूल में. वहाँ भी मैं थोड़ा लेजी था. लेकिन हाँ, ये ज़रूर था कि एक केस को अपने लैंग्वेज में एक्सप्रेस करना, अपने तरीके से एक्सप्रेस करना, उसका एक ज़रूर एक्साइटमेंट होता है. एंड आई थिंक दैट वाज सर्टनली अ फैक्टर. इट्स नॉट दैट आई वाज without fear when I started practice and when I started to appear. That anxiety and nervousness is always there. In fact, it's still there. Truth be told, I was in this court this morning doing matters at the Supreme Court, and you have those mild butterflies in your stomach, which I think you should, because you're carrying somebody's stakes. They're not your own stakes, they're somebody else's stakes, and you have to, I think, stay conscious of that. But उस fear, nervousness के साथ ज़रूर ये भी था कि you can express yourself, be seen for who you are as a counsel. I think, yeah, those were very important factors.
In fact, you're right, sir. Of course, I don't argue as much as you do, but whenever I get the chance, that little hesitation is there, which actually keeps you very alert. And I remember a long time back, अमिताभ बच्चन जी ने भी यही बोला था that despite almost 40 plus years of acting, he still has these butterflies, and he's also said it's a good thing. तो मुझे इसमें आपसे पूछना था, कोई आपने चीज़ ऐसी की to overcome it or rather keep it in control ताकि it doesn't prevent you from arguing? Because बहुत लोगों को एक stage fright भी होता है, the fear of speaking before a judge, and it sometimes is a daunting task to argue before a judge as well.
Good question. मुझे तो actually to keep in check और ज़रूरी है. More than, you have to sometimes say less in court.
Yeah.
मेरे ख्याल से वो एक बहुत challenge होता है, especially as a young counsel, to not overcook your case, not say too much, not to try. I've always said this, don't try and show off your knowledge or your preparation in court. Court is not a place for you to perform
or your
and
vocabulary,
grandstand. बिल्कुल
भी नहीं.
You're a professional. So how do you get over it? One is you have to try and know your case inside out. It's easier said than done, because how much ever you prepare, you'll never have 100% grasp on your brief, because the law is a subject like that. Your mind will race. You'll have 100 questions on facts, on evidence, on law especially. And nothing is black and white. Especially with your seniority, I suppose you don't even get easy cases, right? So, mere khayal se, to answer your question, you have to keep a check on what you want to say, right? Not overdo it. Know where to start, right? And ultimately, I suppose it comes with experience that you get centered and you hold your own, and you don't get intimidated by judges. I think that's very important. Court में एक वो factor होता है कि what if a judge bullies you, or what if a judge is not willing to listen to you or engage with you? And that can happen. That still happens, right? And many times as counsels, we misunderstand questions from the court as being an affront. They're not. Good advocacy is response to questions. अगर एक आपसे बेंच क्वेश्चन कर रहे हैं, आप उसका सही जवाब देंगे, बहुत बार आपको फिर आगे बहस करने की ज़रूरत भी नहीं होगी. Because if you've answered a question well, that should take care of it, especially in the Supreme Court. We've been through 2-3 rounds of litigation, hundreds and thousands of pages of a paper book. But sometimes an answer to one question given right can mean the difference between a dismissal and notice and stay. So yeah, I think very important to keep in check what you want to say.
आपके साथ any incident or any experience when you were going and arguing before a judge and you thought maybe this is becoming very, very tricky and maybe it seems like an upfront or maybe it seems like I don't have the right answer as of now. So how did you end up navigating it?
No, this happens quite a few times. Sometimes it happens when you're younger because judges probably bulldoze you a little more when you're younger. Some of them. Some are very kind to you also. I think there's no harm sometimes in playing for time. I see no harm at all. There's no point in just resisting and pushing against a wall. If you feel either that you're not fully prepared to meet a question of the court, there's no shame in saying you're not ready. Or you need to examine that and come back. I'll be honest. If you have the answer, don't shy away. You should stand your ground. You don't have to be aggressive and confrontational, but at the same time, you have to be firm, right?
Firm.
So that you don't get pushed over. But many times you sense that maybe the court is looking for something else. You need to go back with an additional affidavit. You have to go back with more documents. And frankly, sometimes, as I said, on a point of law, you may not have a ready answer. Or the court sometimes itself may want a breather in the case. So if you're reading a judge well, you're reading a bench well, you'll know exactly what to do in that moment. And I've always felt being, upfront and honest to the bench is a good practice.
Also for your standing and reputation and credibility.
I think so. There's no point fibbing or trying to cook up responses if you don't have any. And many, many times, more often than not, I found that, that's a good way to go back to the drawing board. Prepare. It's harder in the Supreme Court, which is final, and as you know, it's super fast. But nonetheless, I think that's certainly something, if you're candid enough with the court, there's no harm in deploying that strategy.
So do you remember the first time you argued?
Yeah,
the first matter.
The first time I argued was actually a non-argument.
Oh.
Because I appeared in a high-stakes matter on the day I had enrolled. My senior, Mr. Holla, was good enough to entrust me that brief.
It was back in Bangalore,
Karnataka High Court before Justice Ravindran.
Oh, Justice Ravindran and Mr. Holla as well.
Mr. Holla left it to me. He didn't come to court. So I was quite isolated. And I had Mr. Acharya appearing on the other side, who's the grand old man of the bar in Karnataka. He's still active in his late 80s. And I think there I ended up saying nothing. And I was lucky that I still got a good order, because maybe the facts were in my favor, or the judge sensed that, let's not send this guy off with nothing. But I still remember my problem, and I referred to it earlier, was that I think I was over-prepared in the matter. I wanted to say something on every point, which frankly is very innocent of you when you're young, because you don't have to tell a seasoned High Court judge that there are judgments on alternative remedy, on maintainability.
Correct. Right. They're at a certain level of IQ already.
Yeah. Surely they don't need judgments on first principles.
Yeah.
That should be a one-line submission. But I wanted to say everything, and I ended up saying nothing. Yeah, so not the best start.
But you still got the order, sir. So did you think at that point of time, these thoughts, there's nobody who's from the legal background in your family. How will I do my practice? How will I start off? What about finances? What was the thought process like when you were starting out?
All very real and valid concerns. And you can't wish them away, which is why the challenge of going independent is real, especially if you don't hail from a legal family. Those challenges are there, even if you hail from a legal family. Maybe to some measure, there's a little bit of comfort, but court is such a real place that you can't get by just on reputation, or family reputation and so on. So they are all very real concerns. I think they hit me when I went independent. When I was actually with my senior, I probably didn't realize how comfortable I was. Because आपका वो cushion होता है.
क्वेश्चन होता है.
मेन क्वेश्चन क्या होता है आपका कि आपकी अकाउंटेबिलिटी नहीं है क्लाइंट की. क्लाइंट तो आपके सीनियर का है, वो प्रेशर आप पे नहीं है, नो मैटर व्हाट. You are being given a brief to argue. You may have drafted it, you may have researched on it, you may have worked very diligently, but the pressure of the client, truth be told, is not the same till that client is your own. और उससे एक बहुत फर्क पड़ता है. तो वो एक कंफर्ट था. एंड ऑफ कोर्स इन सब चीज़ों का फ्लो ऑफ वर्क, recognition, what type of cases you want to do, ethical challenges जितने early होते हैं career में, those can be stumbling blocks for you, right? They can be make or break. और ethical grounds पे एक seniority पे आज आप brief return कर सकते हैं कि मुझे नहीं लेना किसी वजह से. जब आप 25-26 साल के हैं, आपके पास हैं ही 5-6 briefs, अगर वो आपको ethical grounds पे return करनी हो तो बहुत चुभता है वो. तो you're right. I mean, each of these factors is a real factor, but that's why practice is special, that you have to stay the course, you have to stay in the game, and you have to keep at it. There's really no other way.
कोई ऐसा ethical instance एग्जाम के माइंड में आता है?
कब शुरुआत में
सर
नहीं, बहुत से थे. आई मीन बहुत बारी क्लाइंट्स आपसे एक्सपेक्टेशंस ऐसी रखते हैं जो आप कभी अपने सपने भी नहीं करेंगे वो एज अ रिस्पेक्टेबल लॉयर. गिव यू अ वेरी स्मॉल एग्जांपल, नॉट इवन अ हाईली एथिकल चैलेंज, दैट वेयर डू यू मीट योर क्लाइंट, राइट? फॉर एग्जांपल, that's not so much an ethical thing, it's more a posturing thing, right? And I remember Justice Shailendra Kumar, he told me, he said, I would never go to a client's office, or a client's home. Out of the question, it changes the equation, and that was good advice. Yeah. And I went once, I remember. I went, this client had found me somewhere online, तो बहुत कम था, but he probably found me in some directory or something. Phoned up and said, come over for a discussion on some IPR matter. I should have said no, but it was an interesting matter, it was something to do. And I went and I could see.
And शायद ये डायनामिक्स के बारे में भी ना पता हो, ये
नहीं पता हो, लेकिन लगा, देखा, चुभा. तो एक एक करके वो चीज़ें होती हैं. अब उसको अगर मैं स्केल अप करूँगा, ये entirely ethical issues नहीं हैं, but nonetheless principles हैं जो आप अपने लिए select करते हैं. So for example, I chose not to brief seniors as an independent counsel.
उसमें भी चुभता है सर, बिकॉज
बहुत चुभा रोहन, चुभा. उसमें सैक्रिफाइस होता है. कितने आपके मैटर्स आपके पास नहीं आते. गुड बिग फर्म्स फ्रॉम दिल्ली, फ्रॉम बॉम्बे, हु वांटेड मी टू बी ऑन रिकॉर्ड, बट देन टू ब्रीफ सीनियर्स फॉर द मैटर्स, एंड आई हैड टू स्टैंड माय ग्राउंड. बट द पॉइंट इज, अगर ट्रेड ऑफ नहीं होगा तो कैसे प्रिंसिपल्स हैं आपके? मतलब फिर तो नाम के ही हैं,
कन्वीनियंस है, प्रिंसिपल्स तो है नहीं,
और उनका अपना फायदा होता है.
सर इस टॉपिक है, एक्चुअली दिस इज अ वेरी इंटरेस्टिंग टॉपिक फॉर मी एंड आई नो अ लॉट ऑफ पीपल. हाउ डज वन बिल्ड अप एन इंडिपेंडेंट प्रैक्टिस एंड देन कम टू अ पॉइंट कि अब मैं नहीं ब्रीफ करूँगा? यू नो दैट I was telling you just before we started, I had a word with Raj sir also when I started out. He also told me something, but मेरी उनसे भी इतनी detailed बात नहीं हो पाई. So maybe if you can throw some light, how does that transition? When does someone feel now I'm ready, or is it never that?
Actually, you should be ready from day one, to be honest. देखो, temptation ये होता है कि आपको बड़े corporate matters करने हैं, commercial matters करने हैं, लेकिन आपको you should never feel ashamed or beneath yourself to do other cases, right? You should be doing criminal matters, you should be doing regular civil matters, partition matters. Now I took a choice again on principle that I won't do matrimonial law as a counsel, so that was out of the question. But writ work, service work, small paying clients, non-paying clients sometimes, right? Pro bono advocacy. But you should do the cases for what they're worth, for an opportunity to be in court. मैं हमेशा अपने जूनियर से कहता था और अभी भी कहता हूँ कि आपके मैटर्स जब कोर्ट में आएंगे, Don't strut in there when it's ready for admission and final hearing. Even if it comes up on an office objection raised by the registry, at least मैं जाता था. If I want 2 weeks, my lord, to cure the defects, मैं खुद जाता था. There's no shame in that. Because you're in court. And every time you're in court, you're learning something, you're appearing, and you're not feeling left out. Right? शुरू में वो भी बहुत होता है. तो I think, to come back to your question, you have to see yourself as an arguing counsel from the time you start. Maybe not day one. You must learn in a chamber. You shouldn't also grandstand and say that literally the day you...
कि मुझे आता है, सब आता है.
वो तो आज भी नहीं आता है यार. हमें किसको आता है? आप सीनियर्स को देखेंगे जो 50-60 years of practice, like your dad who has 50 years of experience.
At every stage, there's another level.
There's a level. Every case is a challenge, and you can be exposed if you're not on it. So I think you should make that call early. Not say that I'll wait for a stage, because then that stage you can get comfortable also, right? You will get slotted also, right? Slotting भी तो होती है कि ये तो सिर्फ seniors को brief करते हैं. अब उन lawyers की जो है revenue और stream ज़्यादा होगी, glamorous work ज़्यादा होगा. But the real glamour is probably in actually making a good argument in court. If that is your drive and your motivation, then these things become secondary. But you have to then
go for, have the trade-off.
Absolutely.
And for you, when was the time when you made that trade-off?
Very early. As I said, when I went independent itself, I made that call. There must have been one or at the most two matters where I briefed a senior after I was independent. One was a very good experience, again with Mr. Acharya, who I mentioned earlier. And I learned a lot by briefing him, because his preparation, his calmness in court, his strength of first principles, which I think are all very important things in court, I could see in a very high stakes matter. But my second experience, obviously I can't name names, but the second experience was not so good, because a senior practically threw me to the winds. And when the court put a tough question, he simply looked at me and he said, my instructing counsel should be able to answer it. And that's the moment I was convinced, because I was compromised. It's my brief, I'm answerable, but I'm also not able to argue fully. And the senior who I thought is going to hold fort for me has left me to be cooked in court. And it was very embarrassing, to be frank.
It can be.
You know, I was already clear I was going to go that route, but probably that one case was the last straw that broke the camel's back. And I said, chalo, ab se never again.
Never again.
And that's how it was.
It's a good sign from the universe to you. Mr. Sondhi, come back to the lane.
Bilkul.
Then let's fast forward it to when you were getting designated. How does that journey, sir, maybe start or end or happen? The reason why I ask this is because in today's time, when we look at all the senior designations which are happening, many people are saying that senior बनने से काम नहीं आता है. In fact, when people become seniors, they lose a lot of revenue as well. And nowadays, third point, there are so many seniors as well. I know back then, situations may have been slightly different, but उस टाइम वहाँ पे कैसे हुआ?
वहाँ फिर आपका ट्रेड ऑफ होता है. Very clearly in your career, or in my career also, I can tell you, these are those moments when you're at crossroads and you have to reinvent yourself practically. Any senior who's a principal senior would not be then, running a proxy office for filing would expect to be briefed by external AORs and firms and young lawyers for the right reasons. And I said, let me try and be that senior, right? Now that I've been designated. So the first thing I did was to begin to actually give away my own office briefs. I said, what is the point in me as a senior appearing in matters where I have filed wakalat? I mean, फिर तो nomenclature की बात है ना.
It's not the real thing.
Bilkul, with the exception of some cases where clients were very keen that I stay on them, right? Look, this is not, you don't just for gratis giveaway briefs, but a large majority of my briefs, I distributed amongst my former juniors with some others. And I said, all right, let's call my own bluff and see if I get briefed. It took time. It was a slowish process, but that's the only way then that you prove yourself as a senior and grow. And importantly for me, earn legitimacy as a senior. You want your colleagues at the bar. I was designated fairly young, so it was also important for me that my seniors who saw me in court said this was a right decision to let this guy become a senior. And to earn the respect of your colleagues, I've always said, is the toughest thing, right? Your own brethren, your own colleagues at the bar are your toughest critics and your best judges. And I said, all right, then let me try and do the right thing so that people say, all right, this guy's, his core ethical standards and practice is the right thing.
There, reputation is there. Corporate commercial principles are intact.
Yeah. And it's fun because the more you start to get briefed, you begin to enjoy your gown. And just as much as I was telling you कि आपको अपने senior के chamber में वो comfort है कि वो client आपके नहीं है, वो detachment है, एक तरह से you come full circle because when you become a senior counsel, again that slight edge is removed because the client, strictly speaking, is not yours, right? You're carrying that burden, no doubt, but you're not carrying that crazy pressure of start to finish. You know that. That you're the one meeting, strategizing, drafting, moving a memo, bringing it. That is, it's an exhausting process. And the good thing with the gown then is that if you're not in that process, you're one step removed. So you can actually come to court and argue with a certain detachment. Don't get me wrong. It's not that you're detached from the cause and you don't care, but you're one
it's not
step
lack
removed.
of interest. It's detached, being objective in your approach.
See a case for what it's worth. You can express yourself better. The court sees you as an officer, more so as a senior, and you try and meet those standards, which I think are actually for the better. Yeah.
So you think? I mean, ये हम internally बहुत discuss करते हैं I can say in the law firm circle. So I want to share this. Do you think with the seniors, so many people becoming seniors, which I don't know whether it's a good thing or a bad thing, but over a period of time, do you think that this aspect of becoming a senior is getting diluted in the profession? There will be more firms where maybe in-house advocacy will take place, or senior will be a separate branch like it is there in UK?
I think it's already happening. I think from the time I started in 98 to where we are now, I'm seeing a lot more firm partners arguing themselves for various reasons. I think they've realized that they themselves have a good shot at being recognized. That's happening. B, there's probably a cost effectiveness to it. 3, as I said, is probably for the real reason, which is that you're starting to enjoy court a lot more. The type of work has changed, right? At least in Bangalore, commercial litigation picked up a little later. And once commercial litigation picked up, insolvency, company law, arbitration, but naturally firms had a bigger role to play than in more traditional practices. So yes, I think that's part of the reason. My sense is that there is a disenchantment now with the concept of the senior gown, right? That's the sense I get in speaking to colleagues, speaking to others. Is the reason the process? Is the reason that there are too many designations? They're all valid responses, but there is unfortunately a disenchantment
Even
that has come, and in some ways that's a leveler, right? Why should seniors also have that much of a special bite at the cherry? And as you know, in court, ultimately a good counsel is a good counsel.
A good counsel is a good
right?
counsel.
Some of our finest counsels are not seniors. They've chosen not to be seniors, or for whatever reasons they've not been designated. That doesn't
stop them or take away from them.
Yeah.
So speaking about the bar, also speaking about now the bench, I would say, were you interested in ever becoming a judge?
Well, I consented. So obviously I was interested in that sense. I was asked and I consented. And I was actually asked quite a few times before also. Justice Oak was our chief when I consented. But there were quite a few earlier Chief Justices who had asked me, but then I was probably too young then. So those conversations ended there. So was I interested? Yes, of course. And I think it's a call to duty for a counsel, and your right to criticize the system is only valid, I think, if you're willing to then get into it fully and
Get
perform.
into the crutches and
Yeah, so
do the work.
in that sense, it's not that I ever worked towards it, to be frank. I was enjoying my practice and I was too much of a counsel, and I was not willing to do anything outside that narrow line. But was I interested? Of course, which is why I consented.
Now, in hindsight now, the judgeship did not happen for whatever reason. Do you think it's happened for the best? Like for your own practice, for where you are in the current stage of your life, now that you're also in Delhi?
Yeah, most certainly. I think my move to Delhi got delayed partly because of the fact that I had consented, and obviously that was hardly the time then to make the switch. I would have probably moved to Delhi a few years earlier. I feel very liberated having taken that decision to withdraw my consent. I feel happier and lighter, and I'm able to concentrate on my practice. So yeah, in that sense, for me, it's there's no regrets, and I'm the happier for it. But that phase in itself was hard, and anybody who's been through that phase will tell you, you don't deserve as a counsel to be left stranded in no man's land.
Right.
And if you're the kind of person who's not going to do anything to change it, right? It's a tough place to be.
And so what happens usually in that point of time? Is it that you're not able to take on more briefs because it's already in the news that you're going to be elevated eventually, or you have to slow it down?
It's all of those, actually, Rohan, and that's a very stagnant phase for a counsel. And probably that's the most frustrating part of it, that if you've been active in court, and if you're in your mid-40s like I was when I had consented, and that's the time you want to change gears, or at least keep the gear you're in, to be suddenly not being briefed. You're not briefed for multiple reasons. People think you might get elevated tomorrow, so what's the point in spending time briefing you, putting...
Or you might get briefed because you're going to be also...
to a small extent.
To a small extent.
Small extent. Most of the times, it's the other. जैसे that इनकी कल हो जाएगी, कहीं advance में fee दे दी, वापस ना दी इन्होंने, time. What if you're, spending time briefing a counsel? And you on your part also tend to go slow because you're on the cusp of something else. And I remember when I met Justice Oak, after I had consented, and after the collegium recommendation came, actually, when as a courtesy,
second time?
The first time, the first collegium recommendation, as a courtesy, I called on the Chief Justice, and he gave me this advice. He said, please continue practicing. He's obviously, real enough to know that the gap between the collegium recommendation and your actual appointment can be one day, or it can be eternity also. As we've seen, there are good people still waiting.
Happened in Supreme Court as well. We
know that.
We know.
And his advice was very important to me, because on my part, I might have actually taken my foot completely off the pedal and said, I won't go to court at all till the warrant comes. And that to me is the worst case scenario. That if you stay at home twiddling your thumbs, don't get to go to court at all, and there is this indefinite delay. I think that's the worst case scenario. Mine was somewhere in the middle, because I was going to court, not as regularly as earlier for various reasons, but at least I was there. Keeps you sane.
Then after that, so there was, I think, which I couldn't read much online about that, but there was another moment of reinvention when you made a shift to Delhi.
Yeah.
From an outsider perspective, many people think that Bangalore se Delhi to aa rahe. But the challenges of shifting the practice and all of that. So, मुझे आपसे पूछना था, why Delhi? I know it's an obvious question, but why Delhi? And what was the number one challenge that you faced?
Why Delhi is an easy question to answer. It's obvious because the Supreme Court's here. I was in and out of Delhi quite frequently before. But truth be told, that's not how you can practice at the Supreme Court. it's certainly better to be based here if you're keen on Supreme Court practice. And I knew that. And I didn't want to do this hybrid of back and forth.
Or virtually also.
No, it's not the same thing. It's really not the same thing. And therefore, that's the easy part to answer. The challenges, of course, are there. Delhi is a difficult city to move to from Bangalore. Also, to move cities in your mid-40s is a challenge in its own, right? You're uprooting yourself in many ways. It takes time again for work to come your way, right? As I said, it's not that I moved here with a critical mass of cases waiting. It was the same process all over again, probably for the third time in my career.
The third time.
The third time in my career. Honestly, I felt the same way as I did when I went independent.
But you had practice.
I had muscle memory, I think, more than practice, you're right. So, to earn the confidence and goodwill of AORs who want to brief you and for volume of work to come your way. And that's an ongoing process. So those challenges are there. And Delhi is a competitive city. I think it's more competitive than Bangalore.
In what way, sir?
I think the sheer volume and the quality of work and the diversity of work in Delhi is higher. There's no doubt about it. And therefore, the standards in some ways, I think, are higher. There are ethical challenges in some ways also that come here, as you know. I needn't say more. But the young bar in Delhi, by and large, is totally on the ball. And I can see that. And it's not that other cities don't have it. But I think A, the Supreme Court being here, and B, the number of tribunals being here and the diversity of work and that competitiveness and the stakes involved gives Delhi an edge.
And the power center being here, all of this.
No doubt about it. No doubt about it. Yeah.
What's been, sir, when you look back to the practice in Bangalore versus Delhi, in terms of judges or in terms of both clients, what is the difference that you feel? May not be a challenge, but what is the main difference you feel?
Look, when you're comparing Supreme Court practice to High Court practice, I think the key difference is the sheer speed at the Supreme Court.
आपने कैसे practice की speed की?
वो तो मतलब करनी पड़ती है. As I said, मैं पहले भी appear हो रहा था, but now it's more regular. So that's also a form of muscle memory. You get used to that pressure and that approach of benches. And look, frankly, in the Supreme Court, when you're in 136 jurisdiction, you know fully well that one word or two words, SLP dismissed, is enough for the file to go. You're not going to get reasoned orders on day one, right? 99% of the time. Even statutory appeals are sometimes dismissed.
Yeah, they're treated like SLPs, right? And dismissed. Yeah.
So if you know that's what you're up against, in a sense, you have to match up here. And you have to respect the fact that judges are coming red, right? Judges are coming fully red. They have their notes. Law clerks are making full-blown notes as well. Everything's there. So you have no fallback. But I think the charm of High Court practice, and which is why I enjoy going to various High Courts to appear, the charm is that you get, I think, a little more elbow room to express yourself. You can argue a bit longer. Even in admission matters, the spread is a little more. You might get a little more time to argue. You can fully lay out your case, and that's understandable because many times the High Court may be the court of first recourse or second recourse if it's an appeal, right? If it's a writ, then it's first. And that has a charm to it, that you can express yourself a lot more. And that's, I think, a key difference.
And that way you can also polish your skills more and hone your advocacy also.
Well, most certainly. And you have an ability to then approach the case very differently, right? Even regular appeals before the Supreme Court are quick. Right? Unless there's a really serious and a vexed question of law.
30 minutes.
Yeah, absolutely.
20 minutes.
Whereas in the High Court, you can sometimes argue matters for days. And that is a key difference. It's also because, look, when that particular bench or that hearing is not final, and you need reasoned orders at the inception, even the High Court is therefore obliged to hear and approach it differently. So that approach is very important, a very important difference.
Oh, no, absolutely. So in now practicing before Supreme Court and now High Court as well, Actually, let me talk about the Delhi High Court. Of late, what has happened? You've seen what has happened. What is your view, both from an outsider in perspective and now someone who's been in Delhi for a while?
Yeah.
This whole issue of jurisdiction, pecuniary jurisdiction should be 20 crores or 10 crores or now maybe 5 crores. What does this actually mean for a layman? See, as lawyers, all of us know. When all of this is flashed on news, actually a lot of friends are asking me, इसका क्या मतलब है? How does it impact them? So what does it mean for them? अगर आप थोड़ा
frankly, I don't think it impacts the everyday litigant. ये हम जो बात कर रहे हैं, हम IPR jurisdiction की बात कर रहे हैं.
commercial and IPR.
Commercial and IPR, and Delhi High Court has that unique advantage of having an original jurisdiction, which many other high courts don't have. We miss that in Bangalore, for example. तो उस तरह से आप देखेंगे तो original jurisdiction बहुत crucial है, और it's very helpful for a fully rounded experience for a counsel. Of course, you have a divide between the original bar and the appellate bar in some courts. Calcutta has that. But that said, it's a great value, I think, to have an original jurisdiction in the High Court. But that said, to say that a move from 2 crores to 10 crores by itself is unwelcome, I don't subscribe to that. My friends who practice on the IPR side may not like me for saying it. I don't practice much in the Delhi High Court, to be frank. I do a few matters now and then. But there's no harm if district courts are given that jurisdiction. In fact, there's a far more serious issue which has arisen from the Karnataka High Court, which is the entire gamut of regular first appeals. RFAs has been moved to the trial courts, with the exception of the Bangalore City Civil Court, in which case appeals will continue to be in the High Court of Karnataka. And that was a very significant chunk of work that many of us did. And the civil bar in the High Court will be affected by it. But on the other hand, the district bar would say, let us have a bite at the cherry too, right? So we have to look at it.
The whole pie. This
absolutely.
Is a big pie.
If you extend this conversation to, what you call circuit benches, which then become regular benches in the states. When the bench in Dharwad came up and in Kalburgi came up, in Karnataka, and many states have multiple benches, the same argument in a sense plays out. That you're moving work away from the principal bench, and obviously the bar at the principal bench will be aggrieved. But look at the value to those districts that didn't have a high court earlier, right? Look at the exposure there. Look at the growth there. So I think overall we have to take a balanced view of it. You can trust district judges with death penalty cases. Surely you can trust them with an IPR or a commercial matter with 10 crores, right? So long as I think overall, high courts are not chipped away at. See, a very crucial jurisdiction the high courts used to have earlier was the company roster. That was an original.
Company law boards.
Yeah, which moved to the CLB and then to the NCLT. And many of us who I started as a commercial lawyer, winding up company matters. Some of our best judges and the best bar was in those courts. That was an original jurisdiction.
I remember, so उस time, though I was still in law school, बहुत hue and cry हुआ था कि a lot of these winding up matters are going to CLB, etc. Whether they'll be able to do it or not do it, there should be some questions of law jurisdiction जो फिर भी high court में होनी चाहिए.
हाँ बिल्कुल. और उसमें main nuance क्या है कि वो tribunal में जा रहा है. यहाँ तो ठीक है, यहाँ high court से district court जा रहा है. But to move laterally from high courts to tribunals has a different effect and an impact of its own. So, yeah.
So, if you talk about Delhi now, there's a lot of things which have happened in Jantar Mantar of late. What is it signifying of our society as a whole? Pehle to I would want to understand from you about that. People are going, there is CJP, they have their own concerns, there's our government. But what is it overall signifying? Is it first of all good for the country? Let's start from there and then we can say ki ho kyun raha hai.
Look, dissent in principle is always good for a democracy. There's no doubt about it. It's good for an institution and it's good for society at large. If you're not getting contrarian views, then you're living in
Echo
ivory
chambers
towers or
and
echo
echo
chambers.
chambers.
Honestly, and that's never good. So that's the first point. The second thing is these protests were more than CJP. CJP may in some way have been the voice or the face of them. From what I understood, the protests transcended any party. Look, CJP is not even a political party in that sense, right? But it transcended party politics. It was a churn. I am aware that the protests also got infiltrated. They got hijacked in some ways. There were bad elements there who were fomenting violence. But overall, the sense that you had was this was a spontaneous yet very, very visceral response to the system. And there is a churn there, and there is deep resentment and unhappiness. And these are people within you. There are people there who are BJP supporters. There are people there who have never voted. There are kids there who are probably not even eligible to vote. But they all had something to say. And this was not just Jantar Mantar. This started here. But as you know, it spread across the country.
Even outside India as well.
It did.
UK as well.
So you can be, fixated with conspiracy theories and say this was set up, foreign funded, etc. But at a very core level, these were your own people. These are your own people voicing their own concerns. I concede that in some cases the language of that protest was not appropriate, but the anger was real. And you have to listen to them, right? We have to listen to them. Generationally also. Like a lot of people in my generation, I think, were also piggybacking on the protests. And I personally felt this was a spontaneous, sui generis youth reaction. And we had to, frankly, step back and listen. In some cases, admire. In most cases, admire. Sheer courage and clarity of thought. Where did that come from? It's coming from within, right?
From the
and
core.
It was their moment. It was the moment of those student youth protesters. Now, that, to cut a long answer short, has to be given its due place. It has to be listened to. Otherwise, it will repeat itself. It's not going to go away.
And maybe much bigger than.
Who knows?
Why do you what was the reason for this anger, sir?
Well, people are feeling invisible. People are not being seen. At the end of the day, I think that's the real thing. Be it it's not just a neat education thing. That's an important, but it's part of it. If you look at people who were protesting, there were gig workers, there were farmers, there were housewives, right? There were parents who were bringing their children saying, we want a better India for them. There were everyday people who were either invisible or sheer disgusted with the toxicity of the narrative in our society. How much will you, divide down the line, right? How much will you other the other, right? I think there were multiple factors. It's going to be a case study, Ron. It's not easy to answer.
Yeah.
But
I can see many elements at play.
I think there were many, many layers to it. And ultimately, people wanted to be seen and heard.
And they were looking for some change.
Absolutely. And change in the quality of the narrative, in the quality of the conversation. You want to talk about things that are real and important to you. You want to talk about, you also want, you want a positive narrative. You want a positive environment. How much will you chip away only at the toxic side of things, right? Look at those beautiful moments of people coming together across generations, across communities, across classes, right? At least I was very deeply moved to see those. And to me, that's real India. And maybe that's what people are aspiring for.
Wow. I actually never looked at it this way. So thank you for this perspective. If I can share what's on my mind about this. Yes, I also feel that there is a bit of anger or resentment which has been boiling for a while. Now, हमें पता है बहुत सारे factors हैं. Could be lack of a whip or contra which contests the present government for good reasons, not for the sake of it. Or for that matter, they're not being heard. Or that, NEET has, that issue of leakage has happened every year. Almost every year, not just with doctors, perhaps in our industry as well. But never before it's taken this proportion. So the question मेरे mind में यही आया that this is probably because it's a boilerplate of all these causes
Yeah.
saying that they want to change. Maybe the new India that people talk about. The change that I wanted to check with you, and now this is bringing closer to our industry and also globally,
Yeah.
is AI. Can we agree it's a big change?
No doubt about it. It's the most exponential change there's probably ever been.
After maybe even more than internet, I would say. I don't know.
I think it's internet on steroids.
It's the internet on steroids. Well said. Is it helping our industry grow? 2, are you using it? Number 3, I've heard many senior advocates say this. Please don't use AI. Please don't draft your arguments this. It's bad for you as a lawyer. So I just wanted some clarity for my own sake
Yeah.
on these 3 issues.
Look, I belong to that school of thought that is that your core acumen must be preserved. At least for me as a senior counsel, when I'm approaching a brief, I don't want to outsource my arguments or my notes or my thoughts to AI. And I'm often given briefing notes that I can tell in one look are prepared by AI.
Looks very cosmetic, sir.
It looks cosmetic. It's sometimes off the ball. To the credit of those notes, sometimes it goes far beyond what's even needed,
Yeah.
which is good. Maybe it's stretching a case laterally. If I look at it and I know already what my core points are, what my approach to the case is, and suddenly I see a point I haven't thought of, it's welcome.
Yeah.
But from the perspective of the junior counsel or the associate who's preparing it, if you fed in an input and received this output and passed it on, what sort of lawyer are you going to be? What is the growth you're going to have? Is your IQ going to enhance? Is your instinct as a lawyer going to improve? Or are you simply going to be
I agree.
piggybacking on AI? And for me, that's a real concern. Thank God we didn't have it in our generation.
Yeah.
I'll tell you, Rohan, as much as I believe in technology and I think research has been enhanced over the years, SCC Online, Manu Patra,
All those books
et
have
cetera, et
gone
cetera.
become into from CD,
Yeah,
from CD
from
it's become
CDs, that's right, that we put in.
the index, check the case note, man.
Read those judgments for what they are, not just head notes or what AI now is throwing up to you, which can sometimes be hallucinating also. To read those and then come to that one answer. Of course, it was painstaking. It took time. But I think that rigor is fantastic and it should stay with you. And if this generation is missing out on that, then you're missing out on something very special. And your intellectual growth then I think can be in jeopardy. So yes, AI to make you a better counsel, to help you possibly see things that you haven't seen, to take your remit broader is welcome. But your first draft, as they say, should be yours.
Should be yours.
Yeah.
Should come from here.
100%.
So you've had the benefit of getting amazing seniors like Mr. Holla, great mentors. Also a journey from raw to refined. Luckily without AI. Now let's say if I were to take all of this away from you and I would put you in 2026. You're a fresh law grad.
Yeah.
You've not had that pedigree, not experience, none of this. How would you go about now developing your skills when you know there is this easy shortcut, which is just a click away? So how does that one approach?
You'll have to remember that the core of the profession has not changed, thankfully, and I hope it doesn't. Right? And I said this in an answer to an interview I did recently, that every time you think things are changing too quickly, go back to a 1918 judgment of, Allahabad or of Privy Council, let us say. Read it, look at the advocacy there. The core is the same. Crisp, compelling arguments, fine questions of law. Sometimes,
Precise.
yeah, and
Precise.
you're looking for an answer to a question on the CPC. I was arguing a matter recently about whether receivers can be appointed in scheme suits under Section 92 before they are formally leave granted.
Leave granted for the government.
Even in 2026, the answers you will find may go back 80 years and some of the finest judgments. And those questions have been taken head on and answered. It's just an example. So the core of the practice and profession, I believe, will and should remain the same. And it's for you then to pick chambers and pick seniors you're going to be with where you're pushed in that direction. If you're going to be pushed towards this side, then there are two systems, I'm afraid. The how much ever AI you may introduce, I don't think courts are going to start mortgaging their minds. And sometimes you see that it's alarming that you see orders where I've seen some bail orders where non-existent judgments are being quoted. That's a very dangerous trend. It means even some judges under pressure of work or otherwise picking up this fad are reverting to AI and picking up judgments that are hallucinating. That's awful, right? That's a contamination of the system. So I think we have to hold our own. It's more than a legal thing. Let me be honest. It's a philosophical thing. It's almost a challenge for the human race. That how you're going to hold on to your core humanness, right? Your ability to express yourself, to think, to write, like authors, poets, philosophers. Somebody who's going to take years putting a piece of art together. So you have someone on AI who can do it in seconds, not even minutes. It's frightening, right? It can completely denude what being human is, and at least I try and still cling on to what makes us human. Yeah. Sorry, that was a very long answer.
No, but it's also given me a lot of insight into the philosophy as well. Coming back, आप use कर रहे हैं? Do you think it's adding any? Is there case value for using it to in some way?
मैं frankly अपने legal matters और cases में बहुत कम use कर रहा हूँ. Practically not. Where I'm using it is probably for a little more research that I'm doing on my writing. I have another book contract now, which I'm working on. And I find good AI. Again, you have to be careful, right? There's all sorts of AI. There, I find AI useful because it's giving me a perspective of what material, for example, is available in that space. It's then for me as a researcher and a writer to go back, corroborate it. But certainly that AI is... but the AI is certainly giving me a perspective to the material, the literature that's available, which otherwise I may have struggled to find, right? So therefore, it's a great shot in the arm for researchers. But then you can't be bodily lifting it. It shouldn't become your junior at your chambers, right? Where do the lawyers go?
So is it okay we talk about the book that you're writing?
The one right now?
Yeah.
The one right now, I'm afraid, is a little confidential. I can't.
Let's talk about the one that you've already published.
Sure.
What led to that? I know we spoke about you doing your PhD in civil and military relations between India and Pakistan.
That's right.
And I was sharing my dad's experience. You were sharing pre-partition.
Yeah.
What is the thing that captivated you to first of all pursue PhD in a topic which is, I can say, remotely away from law?
The book itself, Poles Apart, which came out a couple of years ago, is my thesis that I reworked and published with Penguin. I've also updated it and adapted it. But the PhD itself happened many, many years ago, must be 15 years ago or so. I can't remember. It happened longer than that. And it happened pretty much when I had gone independent. So the advantage then is that you have more time on hand. And my old Hindi master from school, Dr. Iqbal Ahmed, he told me कि आप पहले MA करेंगे. But I didn't even have a master's, right? I had done my law degree from NLS. It's not that I had a master's even. I went into practice straight away. And I said, sir, MA की क्या ज़रूरत है? नहीं, आप MA करेंगे और फिर PhD करेंगे. So, that's when the penny dropped, that there was somebody actually thinking about me, right? Outside of my work. And initially I wanted to do my MA in English because I thought I didn't want to do an LLM. Because I said whatever research and further study I do should be interesting and outside the law.
Yeah.
There's enough law as it is. But a BA LLB honors, at least in Bangalore University or Mysore University, didn't let you do an MA in English. You needed to have done a BA in English. So these are all accidents, to be frank. So the only thing I could actually do was an MA in political science. That was the only option I think I had. So I did an MA in political science. And then the next question was, what's your PhD going to be in? And I've had an abiding interest in military history. And I thought, and then the Pakistan factor is somewhere there because we are also a partition family. And I think the contrast between the two countries is so sharp, right? It's such an acute contrast, the way our respective democracies have gone.
The two trajectories are completely different.
Yeah, and the military is the X factor or not so X factor, depending on how you look at it. So yeah, I thought that was a very interesting way of approaching it. I had a fine guide at Mysore University, Dr. Asadi. He passed last year. So, one thing led to the other. And that ultimately became the book.
And so what would be the most important takeaway
from the PhD? I think I would say, because a lot of practicing lawyers ask me this, right? Yeah. And I say to them that, I didn't do the PhD in the law. I didn't do it to pad my CV. Like, you don't need to pad your CV, right? And now, frankly, designations are happening basis, partly you're standing at the bar and partly the points you earn basis your academic qualifications. But at least in 2014, when I was designated, that was not a factor and I was never even thinking of that. So if you're doing it in one way to stay in touch with academics, which I think is good. It makes you a better lawyer. But the key takeaway for me is the rigor. The rigor of writing your thesis, right?
Okay, can you explain a bit more? Like, what do you mean by rigor?
The intensity of research, the need to go deeper and deeper into a question, the hundreds of references and footnotes that come into your thesis. They just by instinct, I think, make you approach a brief better. So I found, and this was not something I had thought of, but I found that after doing my thesis, defending my thesis, speaking about it, writing one or two papers on it from time to time, that my approach to regular briefs
suddenly matured.
The rigor with which I would then look at research questions in those matters, and especially if they were public law, constitutional law issues, where it becomes a lot more interdisciplinary in some ways, a lot more lateral. That PhD experience, I think, helped me be a slightly better counsel. So that was not the idea, but that was the dividend.
Yeah, that was the dividend. And sometimes when you go off the street and you find a new route to the same destination, you sometimes pick up new things.
Most certainly.
So what is the plan now for Mr. Sondhi's next 10 years? Where do you...
I have no such long-term plans. I stay at the game. Honestly, yeah. Kya plan hai? Stay at the job, put your head down and work. Try and do good. I think the one thing that's shifted for me in the late 40s, I turned 50 last year, is that I'm trying to try to pay it forward more. I think that's definitely there. I set up an LLM scholarship in my late mother's memory at SOAS for an LLM in human rights.
Human rights.
So I think try and give more, to try and share more. I think that's important for me. But otherwise, I have no plans.
The plan is to continue with the rigor of the profession.
I think so.
So just last, we have a quick rapid fire round.
Sure.
And I'll ask you a few questions off the cuff, and you can feel free to answer off the cuff. And there's very limited time to think about it. So that's
sure.
More like Supreme Court style.
Karan Johar style.
More like Supreme Court. So we do a Supreme Court style. One book that has really helped you as a lawyer.
No one book. It's very hard to answer that. I think as a genre, let me say, reading on caste and to an extent military history have both been areas that have helped me understand society and politics more clearly. But I can't say any one book.
Second, if I were to squeeze your entire almost 30 years of experience, what has been the advice which has worked for you?
Again, no one advice, but interestingly, when I became a senior, one of my juniors gave me the best advice. She
Interesting.
told me, please don't change your style. You know, I was thinking that designation ho gaya hai, now I need to probably be a different type of counsel. Maybe, you know, chill a little or approach cases more gently, be more yielding. But she told me something very important. You've become a senior because you were fighting hard in court. You were bringing something to the table. Please don't change that grain. I think that was important advice. And it's so true, right? If you've been, it's so true.
One advice for lawyers who want to manage work and life both.
Give the other parts of your life the importance they deserve, to be honest. I don't think any profession anywhere is so taxing that you can't make time to do things you love. There will be times you make your vacations count, but I think just fit into your regimen whatever you like. It's theatre or music or travel or good food. There's no shame in enjoying those things.
Yeah, absolutely. Good food and theatre is good.
Absolutely.
One hobby that you do outside of law, completely.
I've written a couple of plays. I love the theatre as a space.
I was waiting for this to come out.
Yeah. So I think reading plays, right? Watching theatre for me is an exciting thing to do.
Any vice as a lawyer you've developed over the years?
Impatience, short fuse.
I think that comes with when your intellectual sharpness increases.
I don't know.
I've noticed
I've
it.
been working on it.
Okay, last. So what, and this is something for which I ask everyone so by the way, sir, we run a 1% lawyer program to help coach lawyers become better in core skills, the core skills that you were talking about. What does it take in your view to fall in the top 1% in your practice or in your country? Like, what does it take, sir?
I wouldn't know. I'm not in that 1%.
What has been the advice?
Look, I personally don't think one should aspire to any labels. But the one advice is you have to, practice with integrity. Ours is a profession, it may sound cliched, but ours is a profession where people are watching you closely and you're in public glare. And it's actually a tremendous profession for you to test yourself for who you are as a person. So yeah, don't drop that ball.
Oh, that's very important. You got me thinking also. Last, if you were not this accidental lawyer, who would you be?
I don't know who I'd be, but who would I want to be?
Theatre artist?
I think so.
Journalist?
No, not a journalist. Yeah, no. Theatre, probably a theatre actor if somebody were willing to cast me. Yeah.
You've already said current job. So if he's listening to you.
Yeah.
Oh, so I think it's been a special conversation. Thank you again, sir, for coming to Beyond Billables.
Thank you for having me.
And I hope that a lot of lawyers, professionals who are listening can actually get a glimpse of how someone can lead a very successful life and also get what they want in their lives. So anything you want to say to lawyers? You said you wanted to give back as well. So what's something you want to tell them? Kuch mind mein aapke ho?
Well,
straight from the heart.
Yeah. I think make more time for those who are fighting the good fight, pushing uphill, pushing against the grain. I don't think civil rights, human rights activists, lawyers get their due. They are the real unsung heroes of the bar. And I think make time for them. If you can't be one yourself, at least acknowledge them, respect their work, right? They are fighting a good fight. Those lawyers who are fighting only for workmen in labor matters, don't judge them. Don't look down on somebody because they're not making the kind of money that you are, or they don't have the glamour that probably your clientele or your work has. I think at least for me, I've been humbled by looking at that segment of the bar who's many times, discouraged or disregarded. But I think they're the real heroes. So make time for them. Yeah.
Thank you, sir. It was an amazing conversation with you.
Thank you, Rohan.
And thank you for coming to Beyond Billables.